Good afternoon, and welcome to Brooks Pierce webinar on OSHA's COVID-19 Emergency Temporary Standard. Nearly 2 years after COVID-19 entered the public consciousness and soon became a pandemic affecting every aspect of life, employers continue to confront a constantly shifting landscape of regulations and rules affecting how they must keep their work sites and workers safe. OSHA recently released a mandate or test workplace vaccine emergency rule, or Emergency Temporary Standard, ETS, that will require all covered employers with 100 or more employees to either mandate their workforce receive the vaccination against COVID-19 or test them weekly to ensure they are not infected. Despite the fact that the ETS is currently blocked by one court of appeals and another court of appeals will next decide whether the ETS passes constitutional, legal, and regulatory authority, the rule may ultimately be upheld and enforced quickly, meaning employers should prepare now. Your presenters today are myself, DJ O'Brien, and Erin Barker. We practice with the law firm Brooks Pierce, which is located in North Carolina, in Raleigh, Greensboro, and Wilmington, serving clients throughout the Carolinas and beyond. We both practice in the field of labor and employment, counseling employers and employees on occasion, in litigation and compliance, including with emerging themes with the COVID-19 pandemic. We have several topics to cover today, and we'll do our best to get through them. Please know that we encourage questions. Please use the chat function at the bottom of your screen to write out your question. We'll try to answer it if it does come in and it's timely, but more likely than not, we'll try to just get to it at the very end. And who knows, maybe we'll cover it in a later slide, but please do send those questions. On the agenda today is the background and timeline for the ETS, covered employers, which is a threshold issue that must first be addressed, best practices to comply, handling religious and disability accommodation requests, always a thorny issue in other contexts and will certainly be so within the context of the ETS. Enforcement and penalties for violations as well, and then a North Carolina specific update as there's been some action on that front. These slides will be emailed to the registrants probably by tomorrow morning, along with a link to this video. Some disclaimers, as with any of our webinars, this is not designed to be specific legal advice. This is for educational purposes only. Erin and I and others here at Brooks Pierce would be happy to confer with you regarding your organization's needs, but must be done so in a confidential attorney-client setting, which this is not. Also, please be aware, particularly with this webinar, that the ETS is subject to change. As I mentioned in my opening comments, there are court proceedings that have already halted the progress of the ETS, and we expect there'll be further developments. The ETS also could be subject to change itself. And it's an emergency temporary standard limited to 6 months, as Erin will explain. Therefore, it certainly could be subject to change on a permanent or short-term basis going forward. With that, I'll turn it over to my colleague, Erin, to talk about the background and timeline of this ETS.
All right, so as DJ said, I'm Erin Barker. I practice out of our Raleigh office. And to start with, I'm going to provide some context on the background and timeline of how we got to where we are today with this emergency temporary standard. So OSHA issued on December 4th, a 490-page document providing a whole lot of information for employers to sift through. But it boils down to a mandate that employers with 100 or more employees develop and implement either a mandatory vaccination policy or a policy allowing their employees to choose between vaccination and weekly testing plus face coverings. And then there are additional reporting and record-keeping requirements that we will be discussing. So why? We are 2 years into the pandemic. It's been almost a year since the FDA first issued an emergency authorization for use of a COVID vaccine. Almost 59% of Americans are currently fully vaccinated against COVID. So a lot of people are wondering, well, why are we doing this now? On September 9th, the White House announced President Biden's path out of the pandemic plan. And this was a 6-pronged plan. And the second prong is why we're here. The second prong was saying to OSHA, hey, you need to write, implement, and enforce an emergency temporary standard mandating that employers with 100 plus employees have their employees be vaccinated or tested weekly. So another question is, okay, we know why they did this, but how can OSHA issue this standard? What is OSHA's power here? And the Occupational Safety and Health Act, its purpose is to assure that every worker in America has safe and healthful working conditions. So once OSHA has established that some health standard is necessary, the Secretary of Labor has almost unlimited discretion to implement standards for that safety. But there's only certain cases where they can implement an emergency standard. So usually there's this whole long rulemaking process that OSHA has to go through. Any standard that OSHA issues has to be reasonably related to ensuring health and safety, and there are limitations through the Constitution and regulatory powers. So here OSHA has said there's a grave danger. They've said that the COVID-19 vaccine poses a grave danger to workers specifically, and that this emergency temporary standard is necessary to protect those employees from such dangers. And in their 490-page document that they issued, they cited a lot of research. It sort of boils down to these factors to support their finding of a grave danger. So OSHA has said that unvaccinated workers are more likely to contract and transmit COVID than unvaccinated workers. There are documented severe health consequences associated with COVID, including illness, hospitalization, death, long-term complications for survivors. The variants, including the recent Delta variant, have resulted in a more deadly pandemic. And there's peer-reviewed evidence demonstrating the transmissibility of the virus in the workplace and the prevalence of infections in employee populations specifically. So far, here's where we are. The text was released November 4th. The standard was published in the Federal Register November 5th. Upon publication, it was immediately effective. The next day, November 6th, the Fifth Circuit temporarily stayed enforcement. November 12th, the Fifth Circuit reaffirmed that stay and said, OSHA, you are to take no further steps to implement or enforce this ETS until further court order. And then as recently as November 16th, all of the cases all over the country challenging the ETS have been consolidated in the Sixth Circuit. So the Sixth Circuit will be deciding the outcome of all of these cases. So where does that leave us? Right now, we're kind of in limbo. For employers who are trying to prepare, as far as we know, this thing is paused. But like I said earlier, it became effective immediately upon publication in the Federal Register on November 5th. And so based on that date, if this ETS goes into effect, currently, most of the provisions have a compliance deadline of December 6th. And then all of the provisions have a compliance deadline of January 4th. And until we're told otherwise, we don't know if these dates will be pushed back. We don't know if there will be an extension of the deadlines. So as of right now, these are the deadlines that are sort of looming on the horizon for employers. So this webinar is really structured for those employers who are planning to comply and who want to have a plan in place and a policy in place for if this ETS survives the challenges in court. There's also a handy chart that you can find on OSHA's frequently asked questions website that gives sort of each requirement of the emergency temporary standard and by which date compliance is required. So this is available online and will also be in these slides that are sent out. Now, if this thing gets implemented and enforced, it's only in effect for 6 months. So an emergency temporary standard can last up to 6 months. During that time, OSHA can engage in this rulemaking process to decide whether it's going to become a permanent standard, but that's probably unlikely with the shifting nature of the pandemic.
Thank you, Erin. And on the timeline, I would just mention that it's hard to know. We get a lot of questions from employers wanting more certainty as to when this might go into effect and what they need to be doing. Our advice has generally been to prepare as if it will go into effect so you can implement a plan, but everything is stayed, including even OSHA actions to prepare for this. There are a range of challenges that will be lodged on the outer layer constitutional as to whether or not this exceeds the commerce clause of the Constitution, more narrow procedural type challenges as to whether or not the OSHA followed the correct procedure for putting this in there, and then also statutory as to whether this exceeds it. So we're going to be monitoring it closely, but given the short time frame, if it does go into effect, we've been encouraging our clients to make the decisions about whether or not they're covered and then whether or not to go ahead and put these procedures in place. With respect to covered employers, this is a threshold issue that needs to be evaluated from the outset. As Erin has mentioned, it applies to, and if you go to the next slide, Erin, 100 plus employees that are counted. And importantly, this is something that needs to be counted on a company-wide head count, not numbers at a particular site. So in evaluating whether or not you're covered, you look at how many people you employ, not at a particular location, but at the employer level, not at the individual location level. I want to distinguish this threshold issue about whether or not you have 100 employees from the issue about what you do with respect to particular employees. So for example, you could have an employee who works exclusively remotely, who is not subject to some of the testing or vaccination requirements, but would certainly count as an employee to determine whether you as an employer are subject to this. Again, it's 100 employees. This includes full and part-time employees. It includes those people working remotely, either at home or in off-site locations. It includes employees who work exclusively outdoors. Temporary and seasonal workers would also be counted if they're there at any point while the ETS is in effect. Essentially, if it were to go into effect immediately before the stay, if you had 100 employees on November 5th, you were covered by this. If you had less than it, you weren't until you went actually over it. So, but you can't go out. If you have over 100 employees on November 5th and it's effective, and then you go below 100 employees, you're still in it. So it's that 100 threshold. Importantly, there are some workers who are not included in that count. Independent contractors. We've received 1 or 2 questions thus far asking about exemptions to the ETS. There are certain exemptions for certain workers who are covered by other categories, but whether or not you consider it as a threshold or an exemption, that independent contractor count is going to be huge. For example, in the trucking industry, it's believed that there may not be much need for them to require compliance with the ETS, at least as particular employees, if they are independent contractors. Most of you who are in HR or in-house counsel with employees that you're responsible for overseeing are aware that there are dangers in classifying people as independent contractors. That same analysis, I think, is still going to apply in terms of evaluating it. Just because you have someone as an independent contractor, in your view, if they are subject to a classification challenge, that could also affect how the ETS would apply. So that's who's in the count and who's not in the count immediately. I should add also too that OSHA provides some examples on its website about how you count employees with respect to that 100 level threshold. So for example, if you've got 70 part-time employees and 25 full-time employees, you're within the scope of the ETS because you have a total of 100 employees combined, part-time and full-time. If you've got 102 employees, for example, and only 3 ever go to one office location, the employer is covered. So it's important at that threshold level, again, take away the classifications about how you might protect that worker, how they might be subject to testing and vaccinations, but whether you as an employer is covered needs to be taking a look at that 100 level threshold. And again, that can be fact specific as to certain employees, and you do in employment law get into a numbers game with all these different myriad statutes that apply to 10, 25, 100. But for this purpose here, you're looking at your total number of employees as that threshold issue. Before going to the franchisee arrangement, I wanted to mention another issue that comes up that we don't have a slide on, but we expect that will be subject to very difficult decisions for employers, and that's the concept of joint employment. Many are familiar with joint employment context under other employment statutes. And so the issue there, of course, is whether or not you treat two or more entities as a single employer for purposes of wages or other reasons. The ETS doesn't say a whole bunch about that situation, but it does say that there could be a joint employment relationship if the safety matters at the work site between those two entities or more are handled as one company. That's going to be very fact specific, but if you have a situation in which you have two entities that have a work site in which they're working that's more than 100 people, and there's centralized control over the safety, OSHA would more likely than not expect that the ETS would be required. With respect to the franchise situation, in the typical situation where each franchise location is independently owned or a group is independently owned or operated, you would not group together the franchisors and the franchisees. They would be treated separately. And the franchisor would only count, for example, the corporate employees, whereas the franchisees would count the individual employees at the franchisee. Of course, as we talked about, if you've got a entity that owns multiple locations, employs more than 100 workers, for example, in a restaurant at different locations, they would be covered potentially by that ETS. I think that with respect to companies that are office-based and are not always having to worry too much about OSHA-specific regulations, this is one area in which you might find yourself all of a sudden dealing with OSHA, because this is going to really affect many office-based locations in a way that sometimes what OSHA's traditional concerns do not. One question we've received early on, if you go to the next slide, Erin, is with respect to state and or local government entities. And this can be sometimes a distinction without a difference, but it doesn't apply in states without OSHA-approved state plans. But states with OSHA-approved state plans will be required to adopt requirements for state and local employers that are at least as effective as the federal OSHA requirements in the ETS. And North Carolina is one of those states. We're going to cover North Carolina specific issues at one of our very last slides. But for now, I'll turn it over to Erin to get to hopefully something very, very practical for you if you've determined that the threshold applies, which is best practices.
Great, thanks, DJ. So here's where we're going to give you an overview of what this ETS requires covered employers to do to comply and some tips on best practices. But just to preface, this information is going to be fairly general to apply to as many employers as possible. So keep in mind that your company may have some specific factual differences that make compliance look a little bit different for you. So of course, we recommend that you consult with an attorney or reach out to us if you have any questions about your specific factual circumstances, because that would be more on the lines of specific legal advice than this sort of general overview information. So the basic requirement, the core of this ETS, requires employers to develop and implement a written policy. So this written policy should either require vaccination for all employees or allow employees to choose between vaccination and weekly testing and face coverings. So you might be worried that your employees are going to refuse to get vaccinated, and you might be worried about losing employees, and that's a valid concern. So you may choose the second option of giving employees a choice between vaccination and getting weekly tests plus wearing face coverings. An employer's policy should, at the very least, address the requirements for vaccination, who's excluded from the written policy, information on how vaccination status will be determined and collected, information on paid time or sick leave for vaccination purposes, which we will talk about later on in the presentation, the procedure for notification of positive COVID tests and removal of positive employees from the workplace, any disciplinary action for employees who do not abide by the policy, and the effective date to whom it applies, various deadlines and other procedures, and so on. So OSHA has provided template policies on its website. So if you search OSHA vaccine ETS, OSHA has a website where it's compiled a frequently asked questions page, and it also has Word documents for both types of policies. So it has a Word document that's a template policy requiring vaccination, and it has a Word document that's a template policy for the choice between vaccination and weekly testing. And it sort of has, fill in the blanks where you can put in your company's name and address all of these different policy matters and fill in any extras. If you have a policy that you think already complies with the ETS, so say you went ahead and implemented a mandatory vaccination policy early on in the pandemic, we would recommend that you review that policy with an attorney to make sure that it complies with all requirements of the ETS. Also, this policy should be made readily available to all employees through your normal methods of distributing information to your employees. And you are not required to submit your policy to OSHA. So there's nowhere where you go and upload your policy unless OSHA requests your policy. So they may do an inspection as part of their enforcement proceedings, and they may ask for your policy. And that's the only time when you have to actually send OSHA your policy is when they ask for it. So covered employers also have to provide certain information to their employees along with the policy itself. This information could be included within the policy, or it might just be a separate document. So employers should be sure to tell their employees information about what the ETS required them to do. So, you can say, we are issuing this policy because of this ETS. They also need the CDC document titled Key Things to Know About COVID-19 Vaccines, information about protections against retaliation and discrimination, and also information about laws that provide for criminal penalties for employees who knowingly supply false statements or documentation. And this is meant to deter employees from submitting falsified vaccine records or falsified test results, which hopefully they wouldn't do, but a deterrence wouldn't hurt. There are also procedures that are required, and your policy has to include information on what happens if somebody has a positive test result. So an employee comes to the workplace and say you're doing on-site testing and their test comes back positive, or an employee goes and gets a test outside of the workplace and it comes back positive. So they have to notify you when they receive a positive test, and you as an employer have to communicate to your employees that they need to notify you. Anyone who's at work who gets notification of a positive test has to be removed from the workplace immediately, and that's vaccinated or not. So whether it's a breakthrough positive result or not, they need to be removed, and they need to be kept out of the workplace until they meet specific criteria for returning to work. And this criteria is outlined in the ETS. It sort of covers how much time the employee needs to be out of work, any requirements for coming back with a negative test and symptom-free, those sorts of requirements. Now, the ETS itself does not require paid time off for an employee who's removed as a result of a positive test, but paid time off may be required by other laws, including federal and state laws, regulations, or if you have collective bargaining agreements, it may require paid time off, like sick leave. All right, so DJ touched on this earlier, but another question is whether all employees have to comply with this policy that's sent out and that you develop. So the ETS does not require these employees to comply. So employees who work exclusively remotely, employees who work exclusively outdoors, and employees who do not report to a workplace where other individuals, including coworkers or customers, are present. And this makes sense. People who work exclusively remotely, they're at home all day. They're not coming in and having this risk of transmitting COVID to another employee, which is what the heart of the standard is really trying to prevent. But for each of these categories, there are some sort of tricky factual situations. So you might have an employee who works remotely and they might need to come into the office for some reason. They might need to come print something, or they might need to come in, once a month. That employee still has to either be vaccinated or submit a negative test within 7 days of returning. So it's only employees who are exclusively remotely, they never ever come into the office, who don't have to comply. There's also some specific factual circumstances for employees who work exclusively outdoors. So say you have a hypothetical employee who works at a construction site, and this employee only installs siding on a house that's being constructed. They never enter the structure. So they're exclusively outdoors. That employee is not required to comply with the policy under the ETS. But those facts can change really quickly. An employee who works outdoors but might work in a partially completed structure, so there's a house being built, and this employee goes into this house and it has 3 walls and part of a roof. That's a partially completed structure, and that employee has to comply because they're mostly indoors. Also, employees who share a ride to work. So they work exclusively outdoors, they're outside all day, but they ride in a work truck with another employee. They have to comply with the policy. So as you can see, it can get a little bit nuanced, and it can have some very specific facts that just kind of change whether the employee has to comply or not. So this is a good time to sort of look employee by employee who has to comply. To make it easy, there's also nothing in the ETS that prohibits you from requiring all employees to comply. So you could say, working remotely or not, working outdoors or not, everybody has to either provide proof of vaccination or a weekly negative test. And that's up to you, whether you as an employer want to have your policy apply to everybody or whether you want to exempt these categories of employees. And also just a reminder that these employees do count when you're determining whether or not you're covered. So you still have to count the employees who work exclusively remotely or exclusively outdoors. This is a separate analysis of whether those employees have to follow the policy.
Thanks, Erin. And before I get into the associated costs that may go along with this, just to pick up on a couple of questions that have come on during my first remarks and yours as to counting employees and other topics. A couple have been related to the school system. That would be one of the situations in which there might be unique counting requirements. So I'd encourage you to consider consulting with one of our education attorneys, such as Jill Wilson, Sarah Saint, or Elizabeth Troutman. Again, if it's a temporary employee, if it's a person who's not traditionally considered an employee, they're likely not going to count toward meeting that threshold. Also had a question as to whether about the CMS mandate still being in effect. Let me mention that the ETS specifically does not apply to employers that are covered by the federal contractor vaccine requirement, the healthcare ETS, which is narrow, not every healthcare setting, or the new CMS rule. And with respect to the healthcare ETS, we had a webinar over the summer, which is still available on our website for folks who may be concerned about that issue. And with respect to these slides, we will again make them available to everybody so they can have the benefit of the information contained therein outside of this webinar. And there will be, I believe, hopefully links within the PowerPoint distributed to take you directly to OSHA and other sources providing guidance. So with respect to who pays for what, it should be of no surprise that OSHA did not consider this to be cost neutral to employers when it implemented it. It was not designed to be cost neutral, as with a number of other employment related statutes. The counter to that would be that if you can keep a healthy workforce, keep businesses open, reduce the overall rates, that it'll be overall net benefits to the economy and to the pocketbooks of our clients and other employers. But the reality is there will be very specific costs associated to businesses with allowing their employees to get, requiring them to get vaccinated, also dealing with side effects of vaccinations, particularly as people are getting booster shots, which seem to take people out of work even more, but then also the testing requirements that are required. So with respect to the cost of vaccination first, employers are required to provide a reasonable time to each employee during the work hours for each of their primary vaccination doses, including for up to 4 hours of paid time at the employer's regular rate of pay. That time period is designed to cover the time you might go there, have to wait, and potential recovery. The maximum of 4 hours of paid time per dose cannot be offset by any other leave that the employee has accrued, such as sick leave or vacation leave. There may be some interest in how this is going to apply to boosters. And I believe that, fully vaccinated still is going, for now, is going, as we sit here November 18th, 2021, will include two doses or one dose of the Johnson & Johnson. But employers may wish to consider allowing for its workforce to get that booster shot and not subject to any type of penalty for work. Employers don't have to pay for transportation costs. You don't need to drive these people to go get vaccinated. They just need to be allowed to do so. And of course, COVID vaccines have been available to everyone, at least in the United States, at no costs. They were paid for with taxpayer dollars with Operation Warp Speed. They'll be given to all people living in the United States, regardless of the insurance or immigration status. And so there should be no concern about having to pay an actual cost for a COVID vaccine shot. So COVID-19 vaccine providers, to the extent that employers are trying to facilitate visits to appropriate providers, they can't charge you for a vaccine. They cannot charge you directly for administration fees, copays, or insurance. They can't deny vaccines to anyone who does not have health insurance coverage or is underinsured. And they can't charge an office visit or other fee to the recipient if the only service being provided is a COVID vaccine. So it's important to know that these vaccines are widely available and employees can easily get one if they're allowed to not be penalized from taking off work to do so. If an employee chooses to receive, as we expect many will, a primary vaccination dose outside of work hours, employers are not required to grant paid time to the employee for the time spent receiving the vaccine during non-work hours. So there needs to be an accommodation there to let them get that, but this is not a situation in which you've got to actively facilitate transporting them there. However, though, if employers receive a primary vaccination dose outside of work hours, employers must still afford them reasonable time and paid sick leave as necessary to recover from side effects that they experience during scheduled work time. And so that takes us to the next slide with respect to vaccination side effects and the associated cost to employers. If an employee has sick leave already, the employer may require the employee to use that sick leave when recovering from side effects, distinction from actually getting the shot. If the employer, as many of our clients do, don't specify between the types of leave, the employer may require the employees to use that leave if they are unfortunately suffering from side effects. And then if there's multiple types of leave, such as sick leave and vacation leave, which other employers do, the employer can only require employees to use the sick leave when they're recovering from the vaccination side effects. And an employer cannot require an employee to use advanced sick leave or go into a negative for paid sick leave if the employee does not have accrued paid sick leave. These can be very difficult questions when you've got an employee who may even have nebulous side effects. And so we encourage you to carefully consider it as you would with any type of request for an accommodation. So while employers are required to provide reasonable time and paid sick leave to employees recovering from side effects following a vaccine. The standard does not specify the amount of paid sick leave that the employer is required to provide for that purpose. Employers could put a cap on the amount of paid sick leave available to employees to recover from side effects, but the cap must be reasonable. The CDC, which we haven't talked about much, notes that although some people have no side effects, if experienced, should go away in a few days, fortunately. And generally, OSHA presumes that if an employer makes up available 2 days of paid sick leave per primary vaccination dose for side effects, the employer is presumably going to be in compliance with this requirement. So apart from vaccination, obviously the subpart of, or the alternative to it is regular testing. Importantly, the ETS makes it very clear it does not require employers to pay for any costs associated with testing. I say unfortunately because there's other requirements that are hidden in there. An employer payment for testing may be required by other laws, regulations, or collective bargaining to the extent that you have a union workforce or other type of negotiated labor situation. So for example, if the cost of testing caused an employee's weekly wage to fall below minimum wage, you're likely going to need to make that up or face a wage and hour violation. Another example would be as if in here the sub-slide or the sub-point, if an employee has reasonable accommodation based on a disability, the ADA would require the employer to pay for the time spent getting tested. So it's, again, with respect to the tested employees, there are myriad of types of questions you might go through. OSHA does not prohibit in the ETS the employer for paying for costs associated with testing required by the ETS. So some employers we've seen are choosing to go ahead and provide pay time off for testing, which is allowed. It's also not prohibited for employers to facilitate the testing or even do it on site, but that's a huge warning area for employers who are attempting to delve into that. But there are ways in which it can be done. And some of our clients are asking, with respect to a large number of people who are going to need to be tested, what's an efficient way to get them tested, get the results back quickly, and not have them all out of the office a bunch of the times. But regardless, the agency OSHA has left the decision regarding who pays for the testing to the employer. And we'd encourage you to confer with attorneys as to specific questions on that. One other thing our clients are doing with respect to considering testing is directing their employees to free testing locations. CVS, Walgreens, others have gotten better at testing in the 2 years since this pandemic started to emerge. And the North Carolina Department of Health and Human Resources has a website with a directory of free testing locations. So those resources are out there, as with the vaccine sites. Testing sites are out there as well to help people on a practical basis comply with this ETS. With that, I'll turn it over to Erin to talk about everybody's favorite topic of record keeping.
All right, so we have our employees getting vaccinated and we have our employees getting tested. And the next question is, how do we record that? How do we satisfy our requirement under this ETS to prove that we're enforcing our policy? So covered employers must maintain a record and a roster of employees' vaccination status, and if you allow for weekly testing, of those weekly tests. As an initial matter to note, this is more of a practical matter than a legal matter. You might find employees saying, hey, you can't ask for my vaccination records, or you can't ask for my weekly tests because of HIPAA. And generally, HIPAA does not apply to the employer-employee relationship. So in most cases, HIPAA does not apply here. But it would be good to think about your strategy, or if you want some sort of standard response of how you're going to address employees if and when you have someone say, you can't ask for this because of HIPAA. Now, even though HIPAA doesn't apply, the roster and records of vaccination and weekly tests are still considered employee medical records. So there still are privacy considerations and concerns with these records. These records should be kept as confidential as reasonably possible. it would probably be a good idea for them to be maintained by HR. They must be maintained separate from the regular personnel file. So they have to be a separate file with employee medical records. They also have to be available for an employee who requests to see their own record. And then they must be maintained and preserved while the ETS remains in effect. So essentially, this is a 6-month record keeping requirement. And then after that 6 months, there are state law considerations for how you dispose of those records. So say you keep physical records of the copies. Different states have different laws about how you have to dispose of those confidential records via shredding in some sort of secure way. So for those records, we have proof of vaccination. If you are requiring mandatory vaccination or allowing employees to choose between vaccination and testing, you're going to need to collect proof of vaccination. So you may collect either a physical copy of the vaccination record, so you can get hard copies, or you can collect a digital record. So you can have employees upload or submit to you a JPEG, a PDF, a PNG, any sort of file. And you just have to maintain those records either physically or digitally. Acceptable records include any sort of official record of vaccination. So there are those CDC provided vaccination cards that you get when vaccinated usually. There are pharmacy records, there are medical records if somebody gets vaccinated with their primary health provider. If they get vaccinated through a state provided service, there could be a state record of their vaccination. Basically, any official documentation that shows what vaccine it was, when it was administered, who administered it, and the employee's name. So you want to kind of check to make sure that all of that information is included. And there is also specific information on what to do if an employee has lost or does not have a vaccination record, but they say they're vaccinated. There is a process outlined in the ETS for what you can do there. And it's this whole attestation process where the employee signs something and to the best of their ability provides information about what vaccine it was, when it was given, and who gave it. So there is an alternate process that you could use if somebody doesn't have a record, and that's outlined in the ETS. All right, next we have record keeping requirements for weekly tests. So if you allow employees to get weekly tests, or if you have employees who have some sort of accommodation to your mandatory vaccination policy to get weekly tests instead, you have to maintain a record of each of those weekly tests. So acceptable tests are those cleared, approved, or authorized by the FDA to detect current infection with COVID, has to be administered in accordance with those authorized instructions, and it cannot be both self-administered and self-read unless proctored. So unless observed by the employer or by an authorized telehealth proctor. So these are those tests where you can buy them over the counter and you can swab your own nose and you can put the swab in the tube and then read the results. An employee can't do that all on their own. Somebody has to watch them do that. So that could be something that you do on site or something that they do through a telehealth proctor. The acceptable tests themselves are any nucleic acid amplification tests, so NAAT. That includes polymerase chain reaction tests or PCR tests. Those are a type of NAAT. PCR tests are probably the most common tests when you go to a drive-up pharmacy and do the swab in your nose. Antigen tests are also acceptable, but it's important to note that antibody tests are not acceptable because they do not test for current infection. They test for past infection and whether your body has antibodies. So those antibody tests are not acceptable. Next, we have some reporting requirements. So just like other OSHA standards, employers are required to report fatalities or inpatient hospitalizations related to COVID-19 in work. So if an employee unfortunately passes away due to COVID-19, and it may have been because of a transmission at work, that has to be reported to OSHA within 8 hours of the employer's knowledge. And employers also have to report any work-related COVID-19 inpatient hospitalizations within 24 hours. So those are the reporting requirements. And DJ is going to telling you how to handle religious and disability accommodation requests.
Handle with care, because this is an area in which I think it would be a wide avenue for people who are looking to avoid being vaccinated or subject to tests that will try to avail themselves of that. So I'm going to talk about religious accommodation requests and then also requests under the ADA. Under the ADA, of course, most of you who have employees are used to going through kind of the interactive process of assessing an undue burden. It's very tough when an employee comes forward with what they say is a sincerely held religious belief to delve into challenging that. It puts the parties in a really uncomfortable position. There are some certain circumstances in which it becomes obvious that the employee is not asserting a religious belief or practice really, but more of a secular or non-spiritual reason for not wanting to get vaccinated. It's not that those people should not be treated with respect, but it's not protected if it's not a sincerely held religious belief. And so you go into the accommodation situation in terms of whether or not something can be held, as opposed to getting into an argument with your employee as to sincerely held religious beliefs if, for example, they are claiming that they're just not able to get vaccinated. The legal standard for evaluating requests for accommodation based on religious beliefs is in practice less demanding than the undue burden hardship standard for ADA requests. But nevertheless, you should evaluate these carefully with scrutiny and recognize if you're going to find yourself into a lawsuit, this is a great area in which to potentially do it. So there should be a process. There should be no magic words that are required. It should be that interactive process. And the undue hardship has to be more than de minimis, but it's probably an easier threshold to cover than under an ADA request. One question we've received in here is if an employee is exempt from receiving the vaccine due to a reasonable accommodation related to a disability or sincerely held religious belief, do they still need to be tested weekly? Yes. The ETS requires weekly COVID-19 testing of all unvaccinated employees, except those exempt from the vaccine due to a reasonable accommodation. However, if the COVID-19 testing conflicts with an employee's sincerely held religious belief, the worker may be entitled to a reasonable accommodation to that. So this is going to be a tough area, and there should be further guidance, not only from OSHA, but from the EEOC. One example as to a reasonable accommodation that we expect to be seen is to provide the employee with the option to get weekly testing and wear face coverings as described in the standard. And that should be sufficient if your policy otherwise requires mandatory vaccination. Or another accommodation could be that the employee is working entirely remotely and thus is not subject to the ETS. And one last thing on religious accommodation requests, the costs include not only direct monetary costs, but also the burden on the conduct of the employer's business in terms of assessing undue burden. For example, courts have found in other contexts that if the accommodation would diminish the efficiency in other jobs, or it infringes on other people's jobs rights or benefits, then that impairs workplace safety. So there's an industry out there of people who don't want to be vaccinated who are developing forms, and you're going to see more and more of these. But I think the key is to focus less on scrutinizing the sincerity of the religious belief and try to move yourself into more of a practical safe zone of what's in your workplace an undue burden. And again, we're always here to consult with you as to specific questions. The other major area I think of accommodation requests you'll get is with respect to disability accommodation requests. And so if you could go to the next slide, Erin. These are obviously covered by the ADA, and it's not anything new with this OSHA temporary standard. The ADA requires that employers offer a qualified employee with a disability a reasonable accommodation if one exists that does not pose an undue hardship. And again, we expect that analysis will be more rigorous for the business or employer to show as to undue hardship than, for example, with respect to the religious accommodation requests. There should be a procedure to resolve these accommodations. Again, there's no magic words, as we often tell our employers in other contexts, that the person doesn't have to come up and say, I need an accommodation. This is not an undue burden. There's no magic words. It's designed to meet the employee at their specific needs. And again, just like with religious accommodations, a disability accommodation could include weekly testing and face coverings for 100% remote work. That's the thing to keep in mind about this ETS. It's a vaccination or weekly testing. And generally speaking, we think that most people who cannot or will not get vaccinated should be subject to the weekly testing requirements unless they can specifically show a reason for an accommodation, not just as to an exemption from the vaccine, but also with respect to the testing. On enforcement and penalties, OSHA has decided to use its authority, obviously, to put some teeth in this. We expect OSHA inspectors will likely enforce on a reactive basis by responding to employee submitted complaints, or include COVID-19 related inspections where they're already showing up on site. So as I mentioned earlier, in an office-based setting where perhaps you're not worried about a forklift falling on somebody and maybe have not had much experience with OSHA, this is a situation in which people in an office setting feel their safety is more impaired. For example, if they believe that unvaccinated people are not being tested, are not wearing face coverings, and therefore would make a complaint to OSHA. There are 1,800 inspectors employed by federal OSHA that doesn't include the state inspectors. And so it'll be interesting to see how aggressive they are in enforcing this if it does come into play. And they're obviously going to have more time as the court challenges go through to gear up. But there is as with masking requirements that some governments have put into place and then also put in some fines, there is a practicality about how much they can enforce this, whether it's due to manpower or just politically speaking, whether they're going to be able to come in and demand this information. We're advising our clients that if the standard does go into effect, that they should absolutely plan on complying with it and being able, as Erin described with the record keeping, to demonstrate it. Another thing too to keep in mind is with respect to any of OSHA's penalties and enforcement, they rely on whistleblowers, and they have protections for those people to come forward in good faith and go to their employer or go to OSHA, and they absolutely cannot be retaliated against. So we think another area of potential liability that the courts will see, not just with respect to denial of accommodation requests, but also will be retaliation claims for people who feel that they've been compelled to come back to the work site when they'd rather be home, who feel that the employer is not doing enough to protect the environment. And a lot of employers have gotten very good about creating safe workspaces, as we all have had to adapt to this pandemic and the changes of the way of life. However, now we have a temporary standard that could go into effect, which could provide even more legal exposure for employers. And if you go to the next slide, Erin, the penalties are potentially very steep. Serious violations are up to 13,000. That's not an ETS specific standard. That's for OSHA violations. General willful violations, 10 times that, 136,000 each. And it'll be very interesting to see how that is enforced, because you could have a violation at one location, you could have multiple violations in different areas, and they will add up and then potentially put your entity at risk. I want to make sure we leave some time to try to get through some of the questions here. So I'll turn it over to Erin to talk about what North Carolina specifically is looking at.
Yes, so our firm is in North Carolina and many of our clients are in North Carolina. So in case employers haven't seen it, there's a quick update on the webinar that happened on November 10th, where North Carolina Labor Commissioner Josh Dobson stated that North Carolina would not be adopting or enforcing this ETS while it's making its way through the court system. And it's sort of unsure what will happen after it makes its way through the court system. So if this ETS passes muster in court and goes into play and North Carolina has its OSHA approved state plan, North Carolina can either implement a standard at least as effective as the federal one, or refuse to implement a standard and could risk federal OSHA coming in. And Labor Commissioner Dobson stated that this is under consideration, but that no decision has been made yet. So while the status of this ETS in North Carolina and really in the rest of the country with the Fifth Circuit stay is in limbo, we continue to recommend that employers prepare to comply and have a plan in place. And then here's the slide with the sources that have all of the links to the websites that we've referenced. So when this PowerPoint is sent out, you will have access to these sources.
Thank you for the questions. I think some of the questions we've addressed in subsequent slides, and we're not going to be able to cover all of them because we will adhere to just a couple more minutes left, and we want to shortly here put up the page for SHRM credit. A couple of the questions have related to employers being required to pay for the times employees spent testing. And there's not a clear answer in the ETS as to on what occasions the employers must pay employees to test. And it only states that the emergency temporary standard does not require employers to pay for any cost associated with testing. And so the question there is, well, does the cost associated with testing include paying for time spent testing? And there's not a clear answer right there. Under other regulations in the current Department of Labor guidance, employers are required to pay employees for time spent waiting and receiving medical attention, including COVID-19 testing, at their discretion or on their premises. So you could easily have a situation in which there's control or direction during the workday place being given to an employee where the FLSA, the Fair Labor Standards Act, would apply, and that is compensable time. So it's going to be a tough situation. There could be further guidance on that. And in fact, I believe the Department of Labor has said that they, with respect to its wage and hour division, will be providing guidance on how the ETS affects wage and hour laws. We thank you very much for your time today. We hope it's been informative. There certainly is SHRM credit for this. We will be emailing out the slides and a link to the video most likely by tomorrow morning, which will contain not only the slides and the information therein, but also links to other sources. And again, we are obviously very happy to speak with you today, but also would welcome the opportunity to confer with you about your specific needs.